Good afternoon. This is Scott Jones, and I'm here with Amy Keeney, and we are glad to have everyone here to listen to this webinar and to view this webinar that Adams and Reese is putting on about cybersecurity outlook for financial institutions. I wish we could be in person together. I see some friends and some colleagues in the attendee list today, and we're happy to have you. And if you have any questions today, feel free to put them in the question box, and we will do our best to answer them as we go through the webinar, or maybe we can talk offline. So to get started today, what we're going to be covering deals with a lot of cybersecurity issues that have kind of arisen over the last year or so. We have some things that have popped up that have already been implemented, and we also have some things that are being talked about. So there's been a lot of emphasis on cybersecurity. If you don't know anything about cybersecurity, you haven't been listening for the past couple of years. But there's a couple notice of proposed rulemakings that Amy is going to talk about today that I think are going to be impactful to the financial institution and the banking world, and it's something that you need to pay attention to. So again, they're not rules yet, but they might be soon, so you need to pay attention to what's going on. And then I'm going to talk about some changes that actually have occurred or are about to occur that are a little more definite, that are more in the payments world and or the bank operations world. So with that, let me just give a disclaimer of this is really meant to be for educational purposes. We think what we're going to tell you is authoritative and accurate. But if you have specific questions regarding your specific institution or facts that you may be dealing with, you need to run those questions by competent legal counsel. So with that, let me give my introduction. Again, my name is Scott Jones. I'm a partner at Adams and Reese, and I focus in the world of payments and bank operations. And a lot of my practice deals with consumer and business treasury management issues, Reg E issues, wire transfer, fund transfer, fraud issues, check, Articles 3, 4, and 4A are where I spend a lot of my time. So that's what I do. And then I'm gonna turn over and let Amy Keeney introduce herself, and she'll tell you a little bit about who she is, and then she's gonna get us started today.
Thanks, Scott. Pleasure to be here with you today. Hi, everyone. As Scott said, I'm Amy Keeney. I am coming to you guys from somewhat overcast Atlanta, Georgia today. I'm a partner with Adams and Reese, and I'm also our financial services regulatory and compliance team leader, which is a mouthful, but that is to say I lead our regulatory and compliance team that services entirely banks and other financial services clients. I like to joke that I grew up with the CFPB. It's a joke, but only loosely in a way. I graduated from law school a month before Dodd-Frank was enacted into law. So, and obviously Dodd-Frank is what created the CFPB. So I've spent most of my career growing and watching the CFPB, and I'm very conversant on all things CFPB really, but lots of consumer protection statutes, particularly on the federal level, but then also on various state levels within our footprint and really across the nation at this point. I also am a pretty seasoned litigator. That's actually how I cut my teeth in the wake of the downturn after the 2009 crash. So I've been around. I do a lot of the consumer financial regulatory stuff for our firm, along with Scott and others on our team as well. So today, we're going to be talking about cybersecurity incident reporting standards. So I neglected to mention in my little spiel about myself that I'm also a certified information privacy practitioner, which means that I also do a fair amount of privacy and cybersecurity consulting work as part of my practice. I picked this up a few years ago when I started seeing that a lot of the regulators were starting to expand and put their teeth into more of the data management aspects that banks and financial services companies hold, because banks and financial services companies hold a lot of sensitive consumer data. And I noticed that a lot of the regulators were starting to move into that space and we're starting to watch a lot of what our clients were doing with their data. So I have expanded my practice into cybersecurity and data management. on that note, our first topic that we're covering today, are financial institutions looking at a new reporting requirement for cybersecurity incidents? Short answer to that is very likely so in the near future, and we'll go into a little bit more detail about that in today's presentation. So the first proposed rulemaking I'm going to be talking about today is the FDIC, the OCC, and the Federal Reserve's notice of proposed rulemaking about cybersecurity incidents. Now, this was actually published in December of last year, so December of 2020. So this was before the change in administration, and I'll make a note of that, and we can discuss that more fully towards the end of my portion of the presentation. But they issued a notice of proposed rulemaking suggesting two main items. The first one is the big one that we're going to focus on today, is that banks will need to report certain cybersecurity incidents, and I'll talk to you more about the terms and the definitions in a later slide, to their primary regulator within 36 hours. The second one is less significant, and we'll discuss that too, is bank service providers will need to report certain cybersecurity incidents to their banks immediately. I know some of you are looking at that and thinking 36 hours seems like a very, very, very tight turnaround for this. And in some ways it is, but in most ways it's not. And we'll talk about that a little bit. And just a quick note too, I'm gonna say banks during this presentation, but the rule actually applies to the term, in quotes, banking organizations, and that term is defined differently by the three different regulators. So it can cover everything from national banks to federal savings associations and bank holding companies. Those would be the banking organizations that would be governed under this proposed rulemaking, unless the regulators change something before the final rule. I'm going to say banks just because banking organization is kind of a mouthful. So there are two key terms that you're going to want to know before we talk about exactly what the rulemaking is proposing. And the first of these two is computer security incident. You'll see that definition on your screen right now. You'll note that the focus of both of these prongs is pretty clear. It's a cybersecurity incident that harms the confidentiality, integrity, or availability of the banking's operations, the core operations, their information system, or their information. This is a slight departure from the way the regulators have been approaching cybersecurity and data management for banks in the past. Really, in the past, their focus has been on incidents that would affect consumer data, or incidents that would compromise consumer data, or in some way make consumer data available to third parties in a way that shouldn't be. This definition does a pretty hard left turn from that and really focuses on the confidentiality and the integrity of your operations in your banking organization. So really, a good rule of thumb for computer security incident, and I know that you're seeing the definition on your screen right now, and you're probably thinking that's pretty vague. I tend to agree with you. This could be pretty much any sort of an incident that either is an imminent threat of your security policies, your incident response plan, it's imminent threat of triggering your incident response plan, or it could result in any sort of a harm to the availability of one of your operations. But a good rule of thumb is where a bank's systems are being taken offline for a certain amount of time, and that's tend to be rule of thumb is 4 hours or longer, you are probably looking at a computer security incident. So that's the first key term that they're proposing, is computer security incident. Second key term is notification incident. So you'll take, the definition is on your screen right now. You'll note that it starts by saying a computer security incident that the bank believes could materially disrupt, degrade, or impair those three items. You'll note that it includes the definition of computer security incident. So that means this notification incident is a narrower subset of the computer security incident term. So in another way, not every computer security incident is going to be or going to rise to the level of a notification incident. The notification incident, the thing that distinguishes it from the computer security incident is that it has to materially disrupt, degrade, or impair one of the operations. So where a computer security incident is really anything that could harm the bank, a notification incident is one that could materially disrupt, degrade, or impair the operations, business lines, or any sort of a core operations. So where a computer security incident is really anything that could harm the bank, a notification incident is one that could materially disrupt, degrade, or impair the operations, business lines, or any sort of a core operations. So Or interestingly, I'll point out to the third point on the slide, those operations, the failure or discontinuation of which would pose a threat to the financial stability of the United States. Again, I'm not going to belabor this point too much during this presentation. I'm going to hope not to, but a big departure for this rulemaking is that the regulators aren't focused so much on whether the incidents that are affecting banks are compromising consumer data. They're now taking a step back and taking a look and saying, okay, for the U.S. financial industry as a whole, what cybersecurity threats are there? In fact, the regulators in their notice of proposed rulemaking specifically said their goal for this rulemaking was to start gathering data and gathering information about threats to the U.S. financial industry as a whole. So the shift really isn't what the goal, and with this notice of proposed rulemaking isn't to add a regulatory burden to banks. Really, the goal is to gather intelligence as quickly as possible to keep the integrity of the U.S. financial system intact.
And Amy, I'm going to for a second. We had a good question. I think so many of our slides are focused on banks, and as you mentioned earlier, we're kind of using that name generally. But we had a question from someone saying, does this also apply to credit unions? And I think the answer is clearly yes. This obviously this is not enforceable yet, but the notice of proposed rulemaking is looking at the financial system as a whole, so that would include our credit unions as well as other financial institutions.
Yeah, so I would, again, with a caveat, if it depends on what the regulators actually publish as their final rule, because again, this is a notice of proposed rulemaking. The NCAU is not one of the regulators that are proposing this rule. So it depends, it remains to be seen if they will adopt some of these rules, likely so. They are part of the FFIEC, so they will likely be adopting this rule in either the verbatim form or something very similar to what is published. But right now, they're not one of the regulators that are being included in this notice proposed rulemaking. But your point is good, Scott. Most likely it will. Something similar to this will apply to credit unions. Again, so I was saying this is a pretty big shift for the regulators, and the goal is to gather information to protect the U.S. Financial industry. And so you might still be thinking, yeah, 36 hours is still a pretty tight time frame. Unfortunately, if any of you have had the misfortune of having a front seat to some sort of a cybersecurity incident, 36 hours is not nearly enough time to be able to figure out. You barely know which way is up inside of 36 hours. So a lot of people are probably thinking there's 36 hours in order to notify all the consumers or notify all the stakeholders who have data that have been compromised. That's nothing. There's a big distinction here. So for the reporting to the primary regulators that are being contemplated in this notice of proposed rulemaking, you're really just supposed to be notifying the regulators that something happened in very bare terms. They're not expecting a post-mortem about what happened. They're not expecting for you to have identified the bad actor by that point. They're really just expecting you to report that something has happened. And so that's why the 36-hour time frame is not a huge derivation from anything that's been happening before. They're not expecting a big report from the banks in that 36 hours. So you're probably still thinking, okay, does this change everything for us? No, it really doesn't. The regulators in the NPR already tried to figure out, okay, are there different ways to get this information that will be prudent or that will be more efficient than including this brand new reporting deadline? And there really isn't, because the FFIEC guidelines are really focused more, again, towards reporting incidents that are affecting consumer data or that have some sort of an improper access to consumer data. Really, the consumer data has been the focus, but this one is really just going to be, they just want to hear if you determine that you might have been the victim of a malware attack, you determine that you might have been a victim of some ransomware or something like that. They just want to hear about it. They just want to gather information. So that's really the goal of this rule. And so you remember at the beginning of the presentation, I said there were really two prongs of this. There was something that affected the banks that they have to now report only the notification incidents within 36 hours. Bank service providers must report all computer security incidents immediately. So that's bank service providers are anyone who engages in check deposit, interest computation, mailing. Any key operation of the bank would be considered a bank service provider. Generally, banks have contracts in place with these vendors, and generally the contracts speak to certain timelines in which a vendor must respond or must report any sort of an information security incident back to their bank customers. So again, kind of like with the first part of this rule, does this change everything for banks? Not really. For the service providers, no, again, because there's usually contractual provisions that require vendors to report out incidents in general. For the banks, this does change a little bit. I wouldn't say it changes everything, but it changes things a little bit, because recall that the computer security incident definition subsumes notification incidents. So when a vendor reports back to the bank that a computer security incident has occurred, it then becomes the bank's burden to determine if that computer security incident falls within a notification incident for the bank. So if the bank determines that it rises to the level of a notification incident, the bank now has to notify its primary regulator. So there's an additional layer of compliance, an additional layer of reporting that will be necessary in those situations, but it's not a huge departure. So really quickly, as I mentioned, the notice of proposed rulemaking was published mid-December. So it was published in the Federal Registry January 12th, which means that it gave the public 90 days to provide comments to the notice of proposed rulemaking. So we have about 2 weeks. The comments period closes on April 12th, 2021. So we've got about 2 weeks left in the comments period. As of today, there have only been 4 public comments, and I checked right before we started our webinar too. You'll notice, as is the case with a lot of these, public comments ramp up significantly towards the deadline, and then the day of the deadline, there's usually like twice as many comments as have been posted. But so far, there's 4 comments, 3 of them from the OCC and 1 from a credit union. The one from the credit union is on the screen. It was very positive, and general consensus about this has been it's been pretty positive. I'm highlighting one of the 3 comments from the OCC, or somebody who purports to be affiliated with the OCC, that is a little bit worrisome. That commenter tended to think that the customers should be made aware of all computer security incidents as soon as they're discovered. That's something that we're going to keep an eye on as the comments period goes on, and as the regulators issue their final rule. That would be something I would be a little bit concerned about, is if the regulators decide that consumer notification needs to occur within 36 hours. That would be something of concern, and that would be something that we would want to get involved in. And certainly, if you are on this webinar and you're listening and you have some thoughts and you would like to issue a public comment through the to this NPR, please let us know. We're happy to help doing that, to help you put that together and help you facilitate doing that. And really quick, before I pass this off to Scott, this is really, the NPR from these regulators is really just one NPR. The regulators, obviously, with the change of the administration, are going to become a lot more active in the next year or 2 for certain. Specifically, I think when it comes to privacy and cybersecurity and data management for financial institutions. Besides this NPR, which I've already told you all is a pretty big departure from what the OCC and the FDIC and the Federal Reserve have really been focused on in the past few years, the CFPB is also starting to make some moves in the data management world, specifically with Section 1071. I won't go into a ton of detail, but the Equal Credit Opportunity Act has already been proclaimed by the CFPB to be a very big focus, and it's the new administration. Section 1071 is going to start requiring banks, really all financial institutions, to report small business lending data, kind of like they already do with the HMDA, with home mortgages. It's going to require banks to turn over a lot of significant and sensitive PII to the CFPB, and you're going to need to figure out how to do that securely. We're watching that. We're expecting a final rule to be issued sometime in the next 6 months. So we're watching that, and of course, we'll keep you all posted about that. And then Section 1033 is dealing with third-party and fintech and data aggregator access to bank data. So that would be any sort of data aggregators or apps that share data from financial institutions. The CFPB is looking into what access those third parties have to consumer data. It's led to already some fairly big national banks as late as last year deciding that they were going to cut off third-party access to data. The CFPB has been under this mandate to issue regulations around this space since 2010 and are just now getting to it. So it's just another indication of the CFPB moving from passive to active mode. And it's worrisome for some of our bank clients because it looks like account holding institutions can bear the ultimate liability before it's done with the account level data. With that, I'm going to turn it over to Scott so he can tell you a little bit more about changes in payments related rules.
Yeah, thanks, Amy. And obviously, we had one more quick question if you want to address it, and it's just,
sure.
When do these become effective? When do these notices, proposed rulemaking become effective? So if you want to tackle that, and then I'll jump in.
Sure. So short answer to that is we don't know. Right now, what has been issued by the regulators is a notice of proposed rulemaking, and that's step one in the 3-step process. So they issue the notice of proposed rulemaking, they open it up for public comment, which we discussed. The public comments period closes in about 2 weeks, and then they'll issue a final rule. And with that final rule, once it gets published in the Federal Register, there will be an effective date at that point. So, keep an eye on our social media and keep an eye on our webinar listings. I'm sure we'll be discussing that whenever that occurs, which if I had to bet, I would think would happen sometime in this calendar year.
All right, so let's jump in. We'll talk through a couple changes that have come. I guess one of them went into effect last week, and another one's going into effect in just a couple months, dealing with the NACHA rules. And so we're gonna, if obviously there are a lot of changes that happen in the payments arena. There's a lot of focus on the cybersecurity issues that are out there, and you've seen this being talked about in a very broad way, and it's now starting to penetrate, some of our rules, and that's been true for a number of years. I mean, for example, Amy, if you want to go on to the next slide, under the NACHA rules, one of the things they've been talking about for a number of years, they first put out a proposed rule in November of 2018. And they've continued to do extensions because they've been hearing from people in the industry that it's too quick, it's too soon. That's really going to be the interesting challenge as we take, in a lot of ways, an antiquated financial system that has been doing things kind of, quote, the old way. I think there's going to be a lot of pressure to learn how to do things faster, learn how to do things more creatively. All with that while you have regulators breathing down your back to do it, in a proper way. So it's really going to be a challenge, but these are things that I think are going to be good for the industry in some ways, because it's going to push some modernization to the system. It's going to allow us to really look at new things and how it happens. But what you're looking at now on this slide, this deals with what I think NACHA was seeing repeated and continual fraud claims with. I mean, I personally have handled a number of these across the nation where you had someone that originated a web debit, and the account had never been validated, and all of a sudden a lot of money goes out of there without any validation process. And so what NACHA has done is they've said, okay, effective last week, March 19th, 2021, if you are going to initiate web debits, then you have to do account validation, and that's part of, it's not the only thing you have to do, but it is an active part of what you have to do to be be part of what the quote commercially reasonable fraudulent transaction detection system. So if you've heard me speak ever before on any of these issues, you know, commercially reasonable is an ever-changing standard. It depends on technology, it depends on the law, it depends on what courts say, it depends on what your agreements say, and it depends on what a lot of your peers in the industry are doing. So it's very important to pay attention to what's commercially reasonable and what do we need to do to make sure we comply with the rules as we go forward. But for purposes of this change, you know, account validation has to be done before, you know, if you want to say your process is commercially reasonable. And that's triggered on the first use of the account number, or whenever, is an important point too, if there's a change to the account number. So if it's the same customer, but supposedly it's a different account, you have to do it then too. One thing that NACHA has done here, which is helpful, is they've given a 1-year safe harbor. So there's not going to be any enforcement actions between now and March 19, 2022, so long as you're working in good faith to implement that compliance program. So if you're not doing anything, you do risk that you could get penalized for that. But if you're making some good faith effort there, there's a 1-year safe harbor, so that's good. All right, the next slide. This is dealing with, this is what I was talking about a minute ago about one of the rule changes that's been deferred 3 years in a row now, but it is going into effect and it's not going to be postponed. But this deals with, you know, we're really dealing with your large non-financial institution originators and third-party service providers and senders as well. If you have account numbers that are being stored, you have to render them unreadable. So you have to encrypt them when stored electronically. An important point is if you're not doing them online and you have them in paper form, those paper authorizations, it's not applicable to those. So that's important. So that's effective for all ACH originators and third parties that have an annual ACH payment volume of 6 million or more, effective June 30th, 2021. 1 year later, that threshold goes down to 2 million. So in 1 year, if you're a financial institution or you're an originator and you have $2 million or more of annual payment transactions, then you are going to have to encrypt this. So, you know, it's something for you to think about when, you know, if you are entering into an agreement or if you're a financial institution and you have agreements with your customers, you know, are you putting requirements on those customers to ensure that their data is encrypted? If you're not, you should. That's something to think about. And then, you know, something to think about as you go forward. Maybe you require it for a certain threshold now. I'm always a fan of, if we see the train coming, the train is coming, that eventually this is probably going to go down to a much lower threshold. So you might think about getting out in front of that and go ahead and put that obligation or your requirement on your customers before it's an actual rule violation. Because if you wait till it's an actual rule violation, your customer and you, maybe as a ODFI, you could have ramifications from that as well. So let's go on to the next slide. We're going to talk about.
Real quick, we have a question. So is there anything that we as banks need to change in our agreements to comply with the NACHA rules?
Yeah, so that's, I mean, obviously one of the things I was just mentioning there is, you know, some of those obligations on your customer, even if it's, they don't have a volume of that, you might consider whether you want to start phasing that in, I think is a good thing. You know, and fast forward to the slide we're looking at now, there's some changes coming on the Anti-Money Laundering Act, which went into effect effective January 1st of this year. I think there's some obligations here that you want to look at with your customers, and, you know, are these things that you want to go ahead and enforce with your customers, or do you want to get some certifications from your customers of what they're doing? You know, in the vein of, you know, trying to stop fraud, and, you know, we see a lot of cybercrime coming out of, you know, LLCs created a month before some fraudulent transaction happened, or being formed simply for the purpose of a fraudulent transaction. And some of that has been, we want to promote commerce, right? In the United States, we want commerce to be free. We have states that have made it very easy. You can go out online and create an LLC in 5 minutes, and you pay a $25 or a $50 fee, and you have a company. And so we've made it very simple, but we've also made it very simple for fraudsters to go through a process that really doesn't have a lot of detail about who's behind that company and who's doing that. And I think that's what we're getting at here on this slide. We have, in this act, they have said, that reporting companies, and that's a defined term, there's a lot of exceptions to that. So it doesn't include banks and insurance companies and charities, and there's some other types of entities that aren't included. But what is included are a lot of these LLCs or these small companies where we need to know who's behind the wall, who owns it. And what this act has done is has put a federal requirement on the beneficial ownership registry, and any person that has substantial control or has ownership of control of 25% or more of an entity is going to have to register in this federal beneficial ownership registry. And if you don't do it, there's civil penalties of $500 a day with criminal penalties up to $10,000 and 2 years in prison. So they're taking this very serious. FinCEN will be issuing regulations on this, and those are likely to be coming sometime in July or August, at least some kind of initial draft of it. But this is going to be very important. I think it's going to be important that financial institutions understand this process, and again, put that obligation on your customers to get this done. And if they don't, make sure you have indemnities so that these penalties don't somehow end up in the lap of a financial institution. All right, next slide. So basically, if you don't do what they've said in the new act, they've created some new penalties and enforcement actions. So a lot of this focuses around knowing concealment and falsification, misrepresentation. But I mean, if you own a company and you don't identify anyone, so let's say Amy and I own a company together and it's 50-50, and I go in and I just say I'm the only owner, and they come back and find out that she was an owner, she was actively involved in it, she has 25% or more value, it's going to be pretty easy for them to say we knowingly concealed that. I mean, you'd have to have a pretty good argument to say this was a total mistake, or I typed it in there and the computer didn't work, something really random like that, I think. But it's the important thing here is make sure your customers do it, make sure they get it done, because there's real penalties behind this, especially if you are dealing with political figures, foreign political figures, and any companies that have assets valued of 1 million or more. That's where some of these crimes kick in. And I think part of that too is they're trying not to penalize the really small mom and pop companies, but they also want to make sure we're getting the information we need to be able to monitor the activity of these companies. There's penalties for BSA violations and enhanced penalties for repeat offenders. Let's go on to the next slide. I know we're short on time here. We said we were going to keep this 30 minutes. So I think this is the last slide we have here. But one thing to remember, there's a lot of changes to the law under the Anti-Money Laundering Act. We could talk probably for an hour just on these changes alone. I'm trying to just highlight the ones that are related to cybersecurity issues, things that might be interesting to financial institutions. But one important definitional change is that they've included within that definition of financial institution, businesses that exchange or engage in the transmission of cryptocurrency, and those that are engaged in the trade of antiquities. So again, do you know what your customers are doing? I mean, your customer may be considered a financial institution if you have customers doing this. So know your business, know what they're doing, know that there's penalties if you don't comply with it. You're going to see from the U.S. Department of Treasury beginning in July, they're going to establish new AML priorities, and a new concept that they put in this law here is that they're going to update those at least every 4 years. So you're going to see a rolling update of priorities that are going to be coming out from the Department of Treasury, and that's going to be something very important for financial institutions to pay attention to. And then there's some information dealing with the information that you might send in a SAR. What you're going to see FinCEN do is to take some, maybe the common fraud, common themes that they're seeing. They're going to package those up and provide that back to financial institutions to say, hey, here's some common things we're seeing, be on the lookout for that. So that's actually a helpful tool that you're going to see back to financial institutions. You should be able to benefit from seeing what those patterns and trends are. And then in the last point there is all these new regulations, all these new rules and requirements, but within all that is that the Act says nothing in this must unduly hinder or delay legitimate access to the international financial system. So they're really focused on how can we put all these regulations in place, how can we monitor for fraud, but not impact the underserved, the underserved banking customers. So the OCC and FinCEN are required to study and report that sometime in the near future. So we'll be looking for that. And with that said, I think that's everything we have to cover. So Amy, if there's any questions, we can take that, or we can close it down.
We do have a few questions, but in the interest of time, we will reach out to you all individually and address them. This has been fantastic. I'm very glad we got a chance to do this, Scott.
Yeah, it's been a lot of fun. I appreciate the opportunity, and it's again good to see some familiar names out there, and hope everybody's doing well. Thank you.